You suggested that, this question is for the gentleman on the left. In your opening remarks, you suggested that the Equal Protection Clause of the Constitution guarantees the right for state employees to collectively bargain. And since the issue of citations came up earlier in this conversation, I would wonder if you'd want to share with us any precedents on a state, local, or U.S. Supreme Court that back up your premise that there is a constitutional right in the Equal Protection Clause to collectively bargain. And a follow-up question that would be, if not, aren't you simply trying to rewrite the Constitution through the judiciary rather than through the constitutionally prescribed ratification process?
Well, I would say two things here. Here's what I would say let me answer the second question first. And the answer to the second question is that it is often the case, if you track constitutional history in this country, that we change what we think about the Constitution in order to adapt to the times that we are in. And what I always say to people who talk about original intent is, tell me if you believe that Brown versus Board of Education was wrongly decided. And if you think it was wrongly decided, why? And I don't think we'd find very many people in this room that would agree that it was wrongly decided, but it overruled 100 years of segregation in our private and public lives. Now, with respect to the first point, one thing that I mentioned in my discussion was a case called O'Hare Trucking versus the City of Norfolk. It's a case that came out of the Seventh Circuit. And what that case did is it drew an equivalency between the rights of public employees and public contractors. And the point of my argument with respect to equal protection was that if a state can validly contract with a lawyer to buy the lawyer's services, or if a state can make a valid personal services contract, or if a state can hire another type of contractor with a contract, why is it that a state cannot contract with a group of people that are its employees who want to have a collective bargaining agreement? Isn't that discrimination based upon them exercising their freedom of association? Now, that's a different case than Smith, which is the Supreme Court case that's most conventionally cited, and it's a situation that's really not been faced by any court. So I would build on Northlake, and I'd build on the patronage cases. The name of the first patronage case is Lewis. That was a Seventh Circuit case. And then, of course, Elrod and the Branty case in the United States Supreme Court.